I'd like to discuss, if I could, the issue of bogus self-employment and the impact it has on Exchequer funding. I wonder, first of all, Mr. Cuddy, if Revenue have an estimate as to the rate of bogus self-employment, or an estimate of what that costs the Exchequer.
We don't have an estimate of what it costs, because it's actually it's like any non-compliant activity to estimate what it is. It's like all the tax gap. It's actually really difficult to put an estimate on any of those figures.
You'll have seen, I'm sure, various estimates put forward by other organisations, actually presented to other committees in this House. One suggested a figure as high as €1 billion. I've seen everything from 80 million up to that figure. Is it something that Revenue prioritises? And I note in one of your own briefing documents the reference to different types of intermediary type practices that are now being used to, I suppose, absolve companies from paying adequate contributions in relation to their staff. Bogus self-employment is probably the most long-standing of those practices. So I'm just wondering if you could categorise where that falls in terms of your list of priorities.
I think it's important to put it all in context, that there's bogus self-employment and then there's actual self-employment.
Absolutely.
And that it also is part of a.
Well, can I just, I suppose, to clarify, what we're talking about are people who work primarily or exclusively for one other company, but that company, through its arrangements, has standardised their employees essentially as self-employed. So we've seen the instances in the construction sector and in other sectors, but that's what I'm referencing. Yeah,
and we've put a lot of work into addressing bogus self-employment. Our joint inspection units, we do regular site visits to the construction sector. But as you mentioned, and as our briefing to you said, that the system has evolved a lot, and I've spoken in here at the previous committee and at the Finance Committee about bogus self-employment, and that the trend is very much towards company structures, personal service companies and managed service companies that are set up to provide the employment through a company to the principal contractor, and we have no legal entitlement to look through that corporate veil. Now, we've carried out extensive projects on those companies and their tax compliance, and it's been the subject of an examination by the Controller and Auditor General a few years ago, and we've done our exercises on medical services being provided through companies and across the board. And part of the challenge there is that there is no legal basis to look through the corporate structure.
There was previously a test case that was presented to the Oireachtas that had been made, actually, I think, by the Department of Social Protection, but with the agreement of the Revenue Commissioners, and that primarily, I think, dealt with the courier sector. I understand that practice has ceased. Can you confirm that? Can you confirm whether a cost associated with that test has been extrapolated? In other words, how much it cost the state, and whether or not it had any legal basis in terms of its implementation? Because I find it very hard to find a legal basis for that test case to have been sanctioned.
I'll have to get back to you about, because when you talk about a test case, I'm not 100% certain. If you have a reference for me, it'll help me.
Okay, well, we'll get that.
Yeah,
it has been publicised in this House. Just finally, you mentioned the inspections or investigations within the construction sector. Could you confirm whether Revenue has carried out any similar type of investigations, particularly in relation to this issue, and within the meat processing sector?
What we do in the meat processing sector is we have keeping an eye on the employment status. Most of the meat companies either have employees or recruit through agencies. And if they recruit through agencies, the agency has a role as the employer in that context. So we're keeping a very close eye on it in the light of, we pay close attention to what's said in this House and on various practices. So we keep an eye on it. We also look for, we're very open to any information from trade unions or anybody with details of regular engagement with various agencies around practices, because the challenge in all this area is that it's a matter of contract law, and if both parties, and sometimes the relationship is obviously an unequal relationship, but unless we can get information that can allow us look beyond something, sometimes we're constrained. The biggest driver, I suppose, from a fiscal point of view is the employer's PRSI. That's the big saving. Yeah. But there are other, obviously, worker rights arrangements which are not our subject of our control. But 2 years ago, I think it was, there was the consultation by Department of Social Protection and the Department of Finance, which we supported, and the report, I think we gave you a link to the report in the documentation we provided, and that highlighted that the challenge around, and this is something that's happened in other jurisdictions where the legislation has looked at effectively a different type of worker, and having different set of rules.
There's a particular type of company that also engaged in this. Can I just, yes or no, can I extrapolate from what you're saying that you accept that there remains an issue in relation to bogus self-employment?
The relevance contracts tax was introduced in the construction sector in, I think it was 1971, as evidence, as a requirement that was needed in relation to subcontracting and its variance. This is a factor across all jurisdictions, and will always, I think, be one that we'll have to take care of. And I think there's a commission on tax and social welfare being set up. I think that it's an area that needs a lot of consideration. Right.
If I could just perhaps prompt them to examine correspondence that was sent to this committee by Revenue on the 9th of August 2000. The reference, I'm told, was PS 3422/00, and that correspondence enclosed letters that were dated the 7th of March 1997 and the 3rd of April 1997 to K. Ryan and Co., which represented courier firms that we were talking about earlier on. And wording in that letter to the Public Accounts Committee at that time said that the letters that I've mentioned outline the agreement reached for tax purposes, and so it just might it might just give you an indication in terms of the issue that myself and the chairman raised. And just to reiterate, it is a crucially important issue, as you know, in terms of bogus self-employment, because of the income that's lost, but also because it breaches the social contract that we're all engaged in, and potentially huge repercussions. We've had a big political debate in relation to the pension age. If we don't take in enough PRSI receipts, then it gives succour to those who want to force people to work longer, and all of the rest. So I would ask for a very tough approach by Revenue. If there's a situation where, for example, 10 people who are working within the same place all have their accounts to you presented by the same company and all have similar work hours and similar arrangements, then you can be fairly clear that there's bogus self-employment. Likewise, if you have somebody working in a meat factory earning the minimum wage, you can be fairly sure they're not genuinely self-employed. Likewise, if you have somebody coming from Eastern Europe that finds themselves working in a meat factory under a new company that's been established, and they've decided out of the goodness of their heart to give that company half of their wages, then there's a problem there. So just that.